So as I say, welcome to our nonprofit webinar, part one, Should You Incorporate? Your lead today will be Benjamin Miller. Benjamin Miller is a staff lawyer at Nonprofit Law Ontario Project of Community Legal Education Ontario, CLEO, where he focuses on nonprofit and charity law and policy. Over the past 4 years at CLEO, Benjamin has answered hundreds of nonprofit law questions and developed an online interactive bylaw builder for the ONCA, which we will link to. It's a very nice tool. Benjamin also works at the Ontario Nonprofit Network and has worked at the Canada Revenue Agency in the past. Benjamin holds a JD and MPP from the University of Toronto and an MA in political theory from the University of Ottawa. And I will hand it over to Benjamin.
Hello, everyone. Thanks so much for coming today and taking an interest in the legal structure of your organization. I will note, because we've got a small group, that it can be more conversational, so feel free to ask questions in the chat throughout. And if Gabe is free of sound and so on, then he can feel free to ask them to me. But there will be a time after each of the three sections of this presentation where we'll stop and pause for questions. So don't worry if you're not comfortable, interrupting. There will be a time. So this presentation will cover three areas. Firstly, the rules that govern unincorporated associations. So even if you're not incorporated, there are certain legal rules and principles that you can use to structure yourself. And a lot of people don't know about them, so I thought that was a good place to start. Not everybody needs to be incorporated by any means. So understanding these rules can be more useful to you if you don't plan on incorporating. Number two, choosing a structure. I'll go over the pros and cons and some of the differences between, for-profit, nonprofits, charities, incorporating versus shared platforms, and different membership structures. And then finally, in the third section, if you do decide to incorporate, that's right for you, I'll give you some information about the different steps that are part of that process. And hopefully I'll have some time at the end to give you a brief tour of the free resources that Community Legal Education Ontario offers, as well as the Ontario Business Registry, which is the online system for the government. That's the new way to handle incorporation. So just a bit of background on the organization I work for. CLEO is a legal aid clinic, part of Ontario's legal aid system. But rather than giving one-on-one advice and services to clients, what we do is we produce education and information in a wide range of areas. I'm a very small part of CLEO. So if you have housing issues, if you have employment issues at your arts organization, human rights and discrimination, immigration and refugee, we have free legal information on all those areas. So I encourage you to be aware of these resources and check them out as is appropriate for you. I am a lawyer, and you know how lawyers are. We need our disclaimers. So number one, this is general legal information. It's not legal advice. I don't know your specific situation and all the variables that might inform the advice I'd give you, so I can't really give advice in this forum, but I can provide some general legal information. Number two, this is a high-level overview of the corporate law aspects mainly in the choice to incorporate or not, but there are other considerations. For example, tax law considerations, which I can speak to if you have questions, but I'm not going to get into the details of. Number three, this is about law. It's not about best practices. As I like to say, just because something is legal doesn't make it a good idea. So I'm going to be highlighting options for you. I'm not going to be telling you what the right answer is because it varies from case to case. And finally, this is about law and not about your funder's expectations. So your funder may have all kinds of expectations about financial review, about how you handle money, about you name it. And it may be consistent with what the law requires. It may be more than what the law requires. I can't speak to every funder. So that's something to keep in mind as you think about the legal considerations that I won't speak to directly. So I'd like to acknowledge the land that I'm speaking to you from. So I'm in downtown Toronto, the traditional territory of many Indigenous peoples, including the Mississaugas of the Credit, the Haudenosaunee, and the Wendat, and is now home to many diverse First Nations, Inuit, Métis. And CLEO's work is carried out across the land that's also known as Ontario. And I want to highlight that I acknowledge my privilege as well as my role in systems of colonization. And what that means in the context of nonprofit law is that corporate law has been used for hundreds of years to evade responsibility for harms done as part of colonization. And that's very much an ongoing process. And secondly, the governance rules. So when we talk about the choice to incorporate and then subject our group to the governance norms and rules under corporate law, one question we can ask ourselves is what alternative or traditional governance systems is this displacing? And if you're feeling a tension between, your organization's desire to be part of reconciliation or to do right by certain stakeholders and the power and rights assigned by the corporate law, if you're feeling that tension, I would love to hear about it and maybe highlight and work through some of the flexibilities that exist in the law. CLEO staff are learning to be better allies by participating in training about the systemic nature of anti-Indigenous racism in Canada, as well as other forms of racism. And we're working to sensitize our information to the experiences of Indigenous peoples and organizations. And so one thing I'll highlight here is that in terms of thinking about honoring the wisdom of the treaties, one lesson that I take from the Dish with One Spoon Treaty that has governed this part of the land for many hundreds of years is that it's manifest in what's called a wampum belt, these intricately woven belts of shells that are brought to every important event, and a messenger, the belt speaks through this messenger to relay the terms of the relationship and then to reiterate the terms of the relationship. So it's one thing to go to the trouble of updating your documents and following all the processes, but if you aren't, revisiting those rules, if you aren't, keeping in touch with the relationships that underlie those rules and that those rules are supposed to condition and bring out, then you've kind of lost touch with what it really means to comply with the law and what meaningful governance is. So one high-level lesson before we jump into the details of the kind of Ontario law is that it's not about just documents, updating your documents, it's about living up to the principles that you set out in your documents. Okay, so the first part of our presentation, rules for unincorporated associations. So we'll begin with discussing what actually is an unincorporated association, how do you start one, constitutions and typical provisions that they include, who makes decisions in an unincorporated association, and how is property handled. So how to start an unincorporated association. So firstly, what is an unincorporated association? Well, from the law's perspective, an unincorporated association is a group of people who have decided to do things together for a purpose or goal other than profit. If it's for the goal of profit, then you may fall under what's called partnership law. And there's in Ontario, there's a Partnerships Act, there's a Limited Partnerships Act. And if your goal is profit, then that may be what you're covered under. But if you're not, your goal isn't to produce profit, then you likely fall under an unincorporated association. And the thing I want to highlight here is that you don't need to register with any government office. As soon as you start working together with you and another person, so two or more people start working together to pursue a goal, it might be painting a mural in your neighborhood, it might be gardening, it might be any number of activities, then you're automatically considered an unincorporated association. Now, the unincorporated association, unlike a corporation, which we'll discuss, unlike a corporation, an unincorporated association does not have a separate legal existence from its members. Fundamentally, the only people that exist legally are the actual people who are part of the association. So what is the association? It's basically a contract between the members. So when we talk about the Constitution, when we talk about the rules that govern it, we're basically talking about a contract between all these people that agree to work together towards a goal. So why does this matter so much? Those individuals each remain liable, legally speaking, for what they do. But the contract governs how they relate to one another. In terms of figuring out what rules apply to you as an unincorporated association, unlike with corporations, there is no statute, either federal statute or provincial statute, that sets out the rules that governs you. So the rules that govern unincorporated associations come from what's called the common law. Basically, the accumulated wisdom of court decisions for the past hundreds of years. And in this area, because it isn't it doesn't very often go to court, there are still cases that are well over 100 years old that apply in this area. So it's hard to find the rules, which is why CLEO has created a webpage on our website to set out some of the basic rules. That's where the rules come from. So you're not looking for a statute, you're looking for common law. Okay, so constitutions. So basically, because there's no statute that governs you, you have a huge amount of flexibility as an unincorporated association to create the rules that make sense for you. And there are two ways that the law recognizes the rules that an unincorporated association creates. The clear way, number one, is where people come together and they write down those rules. They may call it a constitution, they may call it bylaws, they may call it governing rules. The title isn't what matters. What matters is that it's an agreement that everybody agrees to. These are the rules that's going to govern the way our group works. So what are some things that you may want your constitution to cover? Number one, what are the purposes of your group? This is really important to get in writing, both from a practical perspective of having a clear sense of what your mission is, but also from a legal perspective, because the court, if anything ever goes to court, the court is going to look at your purposes and read everything else in light of those purposes, with the assumption that all your other rules should feed and support your purposes. So that's a really important thing to get clear and in writing. Number two, who is a member? Fundamentally, the members are the people with the rights and powers in an unincorporated association. That makes it super important to define who those people are, how somebody becomes a member, what rights they have as members. For example, if you have a common space, who has access to the space, who has access to spend money on behalf of the group, who is entitled to reimbursements, that kind of thing. And also, how does membership end? Is it possible to kick somebody out as a member? If so, what's the process that's followed? This is very important, especially if there's property involved, to define a fair and clear process for how someone becomes a member and how somebody stops being a member. For example, if you have to pay an annual fee and somebody doesn't pay 1 year, at what time do they cease to be a member? Does their membership not get renewed? The next area that constitutions often cover is how decisions are made, and we'll talk a bit about this on the next slide. Unincorporated associations do not have to have an executive. So Gabe received a question ahead of this session, how do we structure our organization as a collective? It's quite possible. And in fact, it is the default rule for unincorporated associations. The court assumes that decisions are made by consensus. You don't have to have an executive. You don't have to have a president and a secretary. The decision-making power can remain with the membership as a whole. You might want to have an executive, and you're free to, in which case the Constitution should define the position, should define how a person is appointed or elected to that position, what powers they have, etc. But you don't have to. The next important area, and we'll talk a bit about this shortly, how the association deals with property. Who does the property belong to? Does it belong to the collective? Does it belong to certain people who lent or gave the property to the collective, but only to be used for certain purposes, but they get it back if the association stops for some reason? All this is really important. And under this heading, who will the property go to if the association closes down? And finally, and this is crucial, how do you change your constitution? So you might come up with a certain set of rules for beginning, thinking the association will work a certain way, and then in practice it shifts over time. That's great, and as I said it from the beginning, that's a natural part of governance to reiterate the changing terms of your relationship. But it's helpful to have a formal process so you can notice the change in those rules and document them. Number one, writing down your rules is the way to formalize your rules. If you do not write down your rules, the way a court would figure out what your rules are is by looking at your common practice. And if you don't have a common practice, if it's very unclear, that could create confusion if something ever goes to court. Okay, so a few points on a very important area: who makes decisions in an unincorporated association? The answer is members of an unincorporated association can structure the association in any way they like. However, if you don't write down how you make decisions, then the court will assume decision-making is based on consensus and not by majority votes. So don't assume that the default way of making decisions is majority voting. How property is handled. The default is property belongs to everyone unless written rules say otherwise. So this is really important if you're, for example, somebody is lending property to the association, but this is never clearly documented. It's just kind of assumed that they'll be able to take it back if something ever happens to the group. The assumption is once something is given to the association, it then belongs to all the members collectively. And all the members collectively decide what happens to it and who gets it if the association ever stops functioning, unless a different rule is written down or the common practice is something else. Okay, so that brings me to the end of describing the basic rules for unincorporated associations. Are there any questions?
Kind of curious, Benjamin, pursuant to your comments sort of there at the beginning, which were specifically with reference to First Nations issues, but they could go to broader issues.
Mm-hmm.
Do you see, or can you outline the sort of circumstances you think might behoove an organization to unincorporate itself in order to get back to that status of not being bound by its corporate charter in terms of its mission?
So you know, in a corporation, and I'll actually get into this in this section, in terms of who has the power. So the people who are defined as members in your governing documents, they have kind of the ultimate power from the legal perspective. And the directors have the legal duties. The members don't have any legal duties to, for example, avoid conflicts of interest. The directors do, the members don't. You know, if you are dealing with a kind of complex environment where you want certain stakeholders in your community to have powers or decision-making to happen in a way where it needs to go through certain kinds of entities, you might be able to do it through the corporate law in terms of defining multiple classes of members, but that might also get really complicated very fast. And that might require you to have a lawyer and have lots of costs and get very legalistic, which could be alienating. And you might be able to achieve the same flexibility and the same respect for different types of stakeholders through an unincorporated association. So, for example, in New Zealand, natural environments like rivers, for example, can have legal standing and rights in an organization. That's not really possible in Canada. At least I haven't heard of any case law that allows a natural environment to have standing. So to do it through the corporate law can be quite difficult. To do it through an unincorporated association, because courts are very deferential. They don't want to get involved in the internal workings of an unincorporated association. It can be easier to do creative things like that if you're interested in giving rights or powers somehow to non-human entities, if you're kind of environmentally minded in that way. So that's just one example. Nothing's come up, so that's why I invite the questions, because I learned from everybody who asks the question. Okay, so that's an unincorporated association. Now, you come here because maybe you're interested in getting incorporated. So in this section, we'll go over—
Benjamin?
Yes.
Sorry, it's Sue. I had accidentally muted myself. I just wanted to respond a little bit to Michael because I forgot to do this in my introduction. One of the reasons that we asked you to address both unincorporated organizations that might be considering incorporation and to address what the new law brings to people who are incorporated provincially is that the COVID-19 pandemic really brought into focus the problems that unincorporated organizations have when they're accessing public funding. So most arts funders in the country at the federal, provincial, or even municipal levels have come to learn how important it is to accommodate unincorporated organizations, collectives, and associations in some way. So they'll usually create a project program or a short-term grants program, something like that, with lesser funding, so lesser public money at risk. And then anyone who is unincorporated can apply in that program. But a lot of the pandemic relief funding was only available to not-for-profit corporations. Whether it was the small business grant in Ontario, that was $20,000, two $10,000 grants, or the portion of the federal loan that you could keep. So that was $40,000 of free money that you could get if you were incorporated, but you could not get it if you weren't. And I think that really shocked people and surprised them. And so more people are thinking about incorporating, not necessarily becoming a charity, which is a whole other ballgame. It's a federal thing, but thinking about incorporating. So that was the flag. We had a lot of phone calls from people saying, we're thinking now that we should incorporate because it's really hit us hard, and we could have done better if we were eligible for this funding.
Yeah, and I will get into more detail about that. So it's a perfect segue to this section. Another simpler point just before moving on that I'll highlight about why somebody may not want to be incorporated, some of the impositions of corporate law is, for example, under the new system, so you have to give an address and it has to be, it can't be a PO box. So for a rural or remote organization, that can be quite difficult because the mail to their addresses are unreliable, or if it's grassroots and they don't have an official address, it's all just home addresses, which they don't want to be publicly available. To avoid the cost of having to go through, let's give a lawyer's address or an accountant's address, so they may choose to remain unincorporated. But on the other side, access to funding and so on is a big consideration in choosing to be incorporated. So pros and cons of incorporating, perfect segue. So pros, protection from liability. As I mentioned, unincorporated associations don't have a separate legal existence. Corporations do, so they're the ones that get sued as long as the people who start it don't themselves engage in kind of negligent behavior. Corporations have a permanent legal existence. An unincorporated association kind of disappears when the members themselves disappear or pass away or stop acting. A corporation lives on, even if it becomes inactive. There's a clear legal framework. So, some people may find the corporate legislation to be constraining. Others may find it helpful to have all these rules set out. And finally, eligibility for funding, which Sue mentioned. A lot of funders, both public and foundations, require that they be dealing with incorporated entities. Some cons, it is more paperwork. There's a cost associated with incorporating, and depending on how complicated your structure is, maybe legal fees and so on, and it's more rigid. And we've talked a bit about that. Okay, so there's a question about incorporated, but incorporating as what? So on the one hand, we have the Business Corporations Act. On the other hand, we have Ontario's Not-for-Profit Corporations Act. There's also the Cooperative Corporations Act. I'm not going to get into co-ops. If you have questions about co-ops, I'd be happy to address them. Co-ops can be either for-profit or non-profit. So the fundamental difference between a business corporation and a non-profit corporation is, with a business corporation, you can pursue any purpose. So you don't have to just pursue profit. You can state other purposes. However, the business is ultimately owned by somebody, the shareholders. So those people are entitled to any excess revenue that the organization generates in the form of dividends. The legal responsibilities of the directors, fundamentally in kind of for-profit corporate law, is to profit. Now, there's some case law which says they can consider other things, which is kind of the shift towards more like social enterprise type stuff, but still fundamentally, for-profit corporate law privileges the directors seeking the bottom line. Thirdly, businesses are not eligible for the same kind of funding nonprofits are. Conversely, they are eligible for some forms of funding that nonprofits aren't eligible for. And they are taxed on any revenues they do earn, but there are all kinds of credits, particularly for small businesses. Nonprofits. So a nonprofit corporation doesn't have shareholders. Nobody owns the nonprofit. Instead, a nonprofit has members, and members have the ultimate authority. They have the power to oversee the organization without owning that organization. So that might reflect the values of your group better. Secondly, nonprofits are tax exempt, but the trade-off with this tax exemption is that nonprofits that are not charities are very restricted in their ability to intentionally earn any surplus revenue. Basically, from a tax perspective, so there's incorporating as a nonprofit, but then there's a question of how that corporation is treated for tax purposes. It is not enough to incorporate as a nonprofit to be tax exempt. You also need to meet the tax test of a nonprofit organization. A nonprofit corporation is free to earn surplus intentionally. You can go out there and you can do business as a nonprofit corporation just as long as you don't pay it back to members in the form of dividends. You can pay salaries, you can do all that great stuff as a nonprofit corporation. But then the question is, how will that surplus be treated for tax purposes? If you are intentionally earning a surplus, basically, it's a bit more complicated than that, but basically you run the risk of being treated as a business for tax purposes. So you're still welcome to do it. You're not being penalized, you're just being taxed like a business. So you lose some of the tax advantages of being a nonprofit corporation. Now, it's a bit different for charities, as I'll get into on the next slide. Thirdly, nonprofits are eligible for sources of funding that businesses are not eligible for. Okay, so nonprofit versus registered charity. So when you incorporate, that is done with either the provincial or the federal government. You can do it under Ontario's Not-for-Profit Corporations Act or the Canada Not-for-Profit Corporations Act. That's one of the fundamental choices you have as part of the incorporation process. Then, if you want the ability to issue tax receipts, so that gives tax benefits to your donors. If you want the ability to receive funds outright from foundations and other charities, then you're engaged in an additional step where where once you incorporate, you then apply to the Canada Revenue Agency to register as a charity under the Income Tax Act. So that raises the question, what do you have to do to qualify as a charity? So the answer is, and simply put, you must be constituted and operated exclusively for charitable purposes. So constituted means that your governing documents set out exclusively charitable purposes. Operated means that in practice, these are the only things you're pursuing. Okay, well, that raises an obvious question. What's a charitable purpose? So a nonprofit corporation can pretty much pursue any purpose other than profit. And there, think of the wackiest purpose you can, I don't know, Spaghetti Art Society collective of Bloor Street, where you only deal with spaghetti art on that particular street, perfectly illegal, right? That's a nonprofit. Does it qualify as a charity? Well, only if it falls within these 4 categories of purposes. Number 1, if it relieves poverty, or number 2, if it advances education, or number 3, if it advances religion, or number 4, if it falls under another purpose beneficial to the community. Now, these are all pretty general. There's lots of case law and there are policies. You can go on the CRA website and they have a guidance products explaining in detail how they understand and define each of these categories. For your information, arts organizations usually fall within one of two purposes. They can have other purposes, but it's usually one of these two. Either a subset of advancement of education, so appreciation of the arts is considered part of educating the public, or other purposes beneficial to the community. And there are a number of different purposes that an arts organization may fall under. It may fall under the promotion of craftsmanship. It may fall under the promotion of industry, if it's trying to benefit, the sector as a whole. And certain appreciation of the arts activities can fall under other purposes beneficial to the community. Now, if an organization does something like arts with youth, or arts with people with disabilities, or arts with seniors or something, then there are other purposes that it may fall under. But typically, if the purposes are just to engage in an art without any further purpose in mind, then it'll be one of those two purposes. And it can get quite detailed whether an organization qualifies or not. Often the thing that trips up and prevents an arts organization from qualifying as a registered charity is private benefit. When somebody is starting an organization basically for the sake of their career as an artist, that will run into private benefit and conflict of interest rules from the perspective of charity law. And there are a lot more restrictions and considerations under charity law than there are under nonprofit law as a whole. That might be a reason not to apply for charitable status. In general, charities are subject to a lot more paperwork and oversight by the CRA, and provincially the office call of the public guardian and trustee. So the CRA and the PGT. Okay, yes, Sue.
Can I interject a short one there on that last point?
Sure, but I think Sue's hand was up, so I'll take Sue's question first and then yours.
Thanks, Benjamin. I just wanted to say that probably 90% of the bylaws and constitutions of arts organizations in Canada that I've looked at, and I've looked at hundreds of them, they will all practically say the same thing under the purpose. It will be just the language that you used for the advanced knowledge, understanding, awareness, and education about the arts. And a lot of people leave it at that, where in my experience, it can get troublesome even if you're trying to talk about benefit for your sector. If the CRA feels that the sector benefits are limited to too few people, you could run into problems. So a lot of the provincial not-for-profit distribution organizations in Canada, like VTAPE or CFMDC, ran into problems more recently when they were slow to incorporate because they benefited too few people in CRA's opinion. So it's better to keep it broad on those bigger topics, in my experience anyway.
Yeah, and CLEO's job is to make it as easy as possible not to have to go to a lawyer, but charity law is one of those areas where a lawyer's help is often
Absolutely
quite useful. Michael.
Yeah, it's great Sue went first because it kind of frames the question. You highlighted those 4 pathways, and one of the frequent comments in talking to artists in the community is that they often get shunted into that providing poverty pathway, teaching children, trying to find their way in through that direction. And perhaps I'm shunting you into things about funders you said you didn't want to speak to earlier. But maybe you could speak to why someone might choose that particular one of the 4 pathways to try and find legitimacy.
So in general, the law is most lenient in the area of relief of poverty. There's a lot more flexibility for, I guess, obvious reasons that the law kind of wants to encourage relief of poverty activities. So it can lead to you get less of a hard time if you're doing promotion of industry. Well, technically it's charitable. The law is kind of ambivalent about it and sort of suspicious. And appreciation of the arts, there's kind of there's a very interesting philosophical question it raises, which what counts as art that is of public benefit, and like what counts as quality art and so on. You know, high level query that we won't get into, what qualifies the CRA to judge that. I'll just leave it as a question, but it's an interesting quirk of the law that it is the CRA's job to judge this. Yeah, so that's probably why it's the path of least resistance in a lot of cases. Rick.
Yeah, just a quick question about charitable status. I've done some searching to see pride organizations around the country, and I haven't found any that have charitable status. And one of the main reasons that I hear about that is that the restrictions around political advocacy and that type of thing. Is that, if you've got a minute to just go over the rules around that in the charitable structure?
Sure. So, you know, I can address the question about political activities, and then also the question of festivals, which I should have mentioned, because that's another category that organizations can qualify under, that a pride parade or pride organization may potentially qualify under. So political activities. So up until 2018, the basic rule was an organization cannot spend more than 10% of its resources, including things like staff time and so on political activities. Political activities were defined as any effort to change or keep a law or to influence a public decision maker in their decision. So pretty broad. Charities absolutely cannot and still cannot engage in any partisan activities. So opposing or supporting a party or a candidate is still completely prohibited. But other political activities, it was allowed up to 10%, and you had to report it as part of your annual return. What happened in 2018 was there was a court case called Canada Without Poverty v. Canada, the Attorney General of Canada. And basically this court case, Ontario Superior Court, found that that restriction to 10% was unconstitutional. It violated the freedom of speech rights of charities, and it was struck down. And the government responded by changing the Income Tax Act, basically saying that registered charities could now engage in unlimited, what it calls public policy dialogue and development activities. A kind of unintuitive name, but it basically amounts to the same thing. Non-partisan, but public decision-making oriented activities. So if an organization wants to keep or change or influence a public decision maker as a registered charity, as long as that activity furthers their stated charitable purpose. So it still has to further the purpose. But as long as it does that, that is now acceptable. So it's opened up quite a bit. So the rules have changed recently. Not a lot of charities know. Organizations are still subject to Elections Act and stuff like that's all different from the charities law. But it's now permissible. Now, an organization cannot have as its purpose to effect a political change. That's not a charitable purpose, but you can engage in political activities to further a charitable purpose. So this gets kind of like splitting hairs. It's pretty legalistic here. So for example, your purpose could be to advance the arts, and then your activity could be, lobbying for increased arts funding. But your purpose cannot be increasing arts funding in Canada because that requires political changes. Now, the question of festivals. So there are certain kinds of festivals can be considered charitable. Whether Pride qualifies for that, I haven't looked into the details of it. But that might be another head to look at. There is a guidance product on CRA's website. So that's a place you could go for more detail. It's fairly restrictive. A lot of different types of culture and arts festivals don't qualify, but it's up there as a possibility.
I guess. Go ahead. Go ahead.
The last thing I should note is that the CRA has a guidance on its name is, it's something like it's not anti-discrimination, it's the pursuit of racial equality. is a charitable purpose that is what do you call it? Not acknowledged, recognized by the Canada Revenue Agency. Under that guidance, it has comments on organizations combating other forms of discrimination. And despite the fact that the guidance is from 2003, it contains a note that says CRA is working on an update for other purposes. So I imagine a pride organization might be interested in the principles embodied in that guidance.
Yeah, I guess the only other comment I was going to make around this, because you've got to get on with the session, but I'm sure there's something in the CRA that talks to how you would actually account, for the level. It sounds like that stuff's loosened up, but I mean, a lot of our activity is online, whether it's posting a petition or information on Facebook or whatever. Entirely volunteer organization, no money is being spent. How would you even account for the level of partisan or activity focused on changing laws or that sort of thing? But anyway, that's a whole separate topic. But it's always sort of baffled me how you could even account for some of that stuff.
Yeah, and with a provincial election coming up, the question comes up again, but under elections law, like at what point do you have to register as a third-party advertiser and so on? And the thing I'd say is that if you have a question, you can always ask the regulator. You can email Elections Ontario, and I've worked with other organizations who have gone through that process, who kind of they nudged and nudged and nudged, and they got detailed answers. So they're there to help as well as to police. They will give you information, so that's an avenue open to you. Sue, I'll take one question, but we do have a fair bit to get through, so that'll be the last question on this section I'll take.
I just wondered if you had any comments on creating foundations, separate foundations, in order to accommodate your charitable status, so that your ordinary non-for-profit did your advocacy work, but you had a foundation that could receive charitable donations and issue tax receipts and did not itself engage in advocacy or lobbying.
Sure. So this is one of the tactics that various organizations use, is where part of their activities are charitable, but not all of their activities. They create multiple entities and they kind of hive off the charitable part to the foundation. And they may use, using a licensing agreement, they may use a common name for each of the organizations, but they'll run the charitable stuff through the foundation, the non-charitable stuff, maybe the political stuff, etc., through the nonprofit, and that's kind of how you keep it separate. So that can be very helpful. The thing always to keep in mind is you have to keep it separate. What often happens is somebody gets the bright idea to create these separate entities, and they set it all nice distinctions, and then over time people forget why the distinctions were made. They start saying, well, this is stupid, we're all one organization really, and they start mixing and matching, and it's the same people involved in this one and that one. The minutes get less detailed, and that's where you start running into problems with the CRA. So it can be a very helpful strategy, but you have to really commit to it and commit to educating the people responsible on how to maintain these distinctions.
Okay, thank you very much.
So the next thing I'll talk about as part of the different models that are available to you is membership models. So as I've mentioned before, members have the ultimate kind of governance power in an organization. So defining who your members are is probably the most, it's one of the most, if not the most, important governance decision that you make in choosing your structure. So I'll go over 6 basic models in a high-level way. So the first approach is open membership. So this can be great for a grassroots organization. You basically say, anybody that supports our purposes, you're a member. Now, the advantage is this is super open and welcoming. The disadvantage is it can be a nightmare to administer, especially if you're a corporation where you have to keep a list of all your members. You have to get quorum for your members' meetings, which may be a percentage of your total members. So the larger the membership is, the harder it is to get quorum. If people don't know if they're a member or not, or if it's very easy to become a member, but they don't realize they may have some obligations associated with it, they may say, oh, I support you, I just don't want to show up to AGMs. So for that reason, open membership can be great and very welcoming, but difficult to administer. Semi-open membership is where you say anybody who meets XYZ criteria is a member. So the XYZ could be pays a fee, files a form, signs a code of conduct. And this can be a great way to be open, but on the other hand, have a clear administrative process. It's also a good way to kind of define the limits of your membership, set the basic rules. If you're going to be a member, you agree to follow, XYZ rule, so that if somebody doesn't, you have a clear way to get them out of the organization. Or discipline them or what have you. Thirdly, self-perpetuating board. I regularly get asked, is this legal? The answer is yes. A self-perpetuating board is where the only members of the organization are the board members of the organization. And so how do you become a member? By being appointed to the board and vice versa. And so this is the advantage of this is it's much easier to administer. The disadvantage is you don't have that external accountability. Some funders, for example, the City of Toronto, I believe, may not fund an organization that has this structure. I don't know if that's true though, so check, and it varies from funder to funder. But I do know some funders are concerned when they see this organizational structure. Fourth, single member. So legally speaking, if you incorporate, the minimum you're required to have is one member. That's usually the founder. That person can have all the power. So if you're a startup, if you're like an entrepreneur and you're incorporating and you're worried, am I going to lose control of my artistic project by incorporating? Legally speaking, you can structure it in a way where you actually keep all the legal power. You can name the board, etc. Now, depending on how you structure it, there are conflict of interest rules and so on you may have to follow, but you can fundamentally keep control of the organization. Whether that's the downside is whether that's healthy or sustainable for an organization is another question. Number 5, hybrid members. So it's possible to have one class, so that just means one type, one class of voting members, and then one class of non-voting members. So members can have different rights. Some of them can have rights to receive documents, go to the meetings, appoint the board and directors. You have to have at least one class that has those rights, but then your other classes could just be entitled to attend. They could be entitled to receive documents. They could be entitled to access certain documents, but not necessarily other documents that voting members can have access to. So hybrid membership is a great way to kind of reflect the interests of different types of stakeholder groups. So for example, if you're a theater, your actors and your production people may be one class of members, your patrons may be another class of members, etc. Representative members. So this is usually used by organizations that have a large geographic area, and then you want regional representation, or you want representation based on, I don't know, demographic lines or something like that. So rather than have everybody in an area be a member, which can be a nightmare, you have everybody in an area is entitled to elect a person, and that person is the member. So that can balance the representativeness with the easier to administer. So shared platforms. So this is basically where an entity makes an agreement with an already incorporated organization. They may already have charitable status and basically says, okay, look, legally speaking, you're the one receiving the money. It's your management and administration. We agree to follow all of that, but we're carrying out the stuff in practice. So the Ontario Nonprofit Network has lots of guides and so on about shared platforms that you can check out. Because we fielded a lot of questions and we're running out of time, I'm just going to give you a high level, the steps to actually incorporate if you've decided that's the right one for you. But I do notice shared platforms, think Tide. Exactly. That's one example of a shared platform. Okay, so number 1, your nonprofit's name. So when incorporating, one of the big steps is you have to pick a name and you have to look, do what's called a nuance search, N-U-A-N-S, get a report that says that nobody else is using your name. It's not the same as registering a trademark. So keep that in mind. You're not getting intellectual property protection of your name or your brand. You're just locking it down for the purposes of corporate law. So you need to get that nuance report, and you can have a corporate name. You can also have trade names. So when you incorporate on your articles of
Whoops.
these are the names we go by in practice, and they're called trade names. Your nonprofits, incorporators, and directors, you need to have at least one person. That's that first founding member, and you need to have at least 3 people who are your directors. Under ONCA, you need a minimum of 3 directors. They have to be at least 18 years old. Interestingly, they don't have to be Canadian residents. So if that's a concern for you, there's a lot of flexibility in that area. And they have to consent in writing. So you need to get that consent in writing. You need to have an address. Remember earlier I mentioned it can't be a PO box. It has to be a physical address. And why is it so important that you have an address? The default is this address will be the place that the government sends important documents to. Board and members meetings by default will take place at this address, though your bylaws can say something else. And important records will need to be kept at this address as a default. Your nonprofit's purposes. So a nonprofit can have any legal purpose other than making a profit. We already talked about that. You can, however, say that our purpose is to make money through a business, like a theater, for example. You charge for tickets, or a museum or something like that. But you then have to say, we're only making this money in order to reinvest it into our nonprofit purpose to further the arts or what have you. I already mentioned charitable purposes. After you have applied to the government and received your letters patent, and this is where a lot of nonprofits, they think, oh, my job's done. Not so. You have to have a first meeting. And basically, actually 2 meetings. One, where your directors meet, and your directors are named in your application as your first 3 directors. You could have more, but minimum 3. Your directors meet, and then your members meet. And your members would be defined as in your articles as your first incorporators, and then in your bylaws. So the directors meet. What do they have to do? Approve a set of bylaws. If you don't approve a set of bylaws, the government automatically applies a default set of bylaws to you, which you can look up online. It may not be right for you, so just be mindful. The directors have to call a members meeting for the members to approve all the decisions that the directors made, and also to appoint the next set of directors, because those first set of directors, they only serve until the first members meeting, that kind of thing. Appoint officers. So under ONCA, the Ontario Nonprofit Corporations Act, you need at least a chair. You don't need a secretary, you don't need a treasurer, though you're welcome to have one and it can be a good idea, but you need at least a chairperson. So once the directors have met and decided all this, and they can do other things if they want as well, then a members meeting needs to happen, and the members need to vote on the proposed bylaws and approve them or change them. If they reject them, then you're getting the default bylaws. They then have to elect a new board and appoint an auditor or a person to do financial review. We don't have the time for it here, but under the ONCA, especially if you're a small organization under 100,000, or if you don't receive public money under 500,000, you don't need to get an auditor. And then you can do all your financial review in-house.
Sorry, Benjamin,
so that we still have a couple
everything you
minutes.
said there.
Yep.
We lost everything, the last bit about auditors and stuff. You were freezing. Could you please repeat it?
So if you're a small organization under $100,000, or if you don't receive any public money, so people not so immediately affiliated with your organization aren't giving you money, including government, then up to $500,000, you don't need to get an auditor. By default, you have to get one, but you can pass a resolution that has at least 80% of support from your members that says, we're not going to get an audit, we'll just do the financial review internally. So you have that additional flexibility under ONCA.
Okay, thanks.
So that's a lot of information. So I know your brain's probably seething, but if there are any questions, you can always feel free to email me. I can't give legal advice, but I can give legal information. And we still have about a minute before the next session. So if there are any questions, I can field them now.
I'll do a quick question, Douglas here. Is there a difference between nonprofit and not-for-profit?
Oh, great question. So we use the term nonprofit just because we find it's the easiest. So technically, it's the Ontario Not-for-Profit Corporations Act. Legally speaking, the actual name is a corporation without share capital, but nobody uses that. That's for corporate purposes. For tax purposes, the term is nonprofit organization. So remember, earlier I said you could be a not-for-profit corporation, but for legal purposes, not a nonprofit organization. So people use it interchangeably. Like it's unless you're speaking to a lawyer who like really cares about these differences, people use them interchangeably. But there are these nuances between corporate and tax law.
Thank you. I'll toss in one more thought then too. We were recently looking into charitable status, and our understanding is that if we had done this 20 years ago, the application would have been very easy, or much easier than now. And now you practically have to write a novel to get charitable status. It's just incredible.
So in terms of the difficulty of obtaining charitable status, in the 70s, it was much easier, like the 70s and before the 70s. That's what obviously, I wasn't around, spoiler, but I've heard that it was much easier. Starting particularly in the late 80s, until now, there was kind of escalating complexity until the early 2010s, when there's been a cooling off kind of from the regulator, where there's been a shift in perspective to what they call an education first perspective. They're not here to police you, they're your friend, etc. And so now what I would say is that it takes like 9 to 12 months on average. It depends the category you're applying under. It also depends what kind of red flags there are. So private benefit can lead to lots of desire to go back and forth, depending on the officer you're interacting with. Other purposes can be much more straightforward. So for example, if you're just a foundation whose purpose is to grant money, that is quite straightforward and can happen much faster. So it really depends who's applying and the complexities involved.
So it is after 2 p.m. So I'm going to suggest that we cut it off for the moment. We will be sending out a follow-up email, most likely tomorrow, with copies of the slides, links to the presentation, and also Benjamin's contact info. So he has offered to make himself available. So if you do have any follow-up questions, you can contact him there. But yeah, I'm gonna suggest that we call this part of the workshop.
Okay, thanks. Benjamin, thank you so much for this part of the workshop. We really appreciate it. And I've taken a look at the resources and information available on the CLEO website, and it's really fantastic. It's really easy to read and understand. So I'm going to encourage everybody to take a look at that. In terms of going forward with a charitable application, EC3 has helped a number of people do that in the sense of reading over your basic grammar and language. And I think I'm going to have to go. That's that important call I was talking about. But thank you, Benjamin. Thank you for everyone for coming. Hello, Sudhita speaking.